Back to mention item number 32. 30? Yes, Lordship. Petitioner is instructed to withdraw
0.
32, 32.
32.
Yes, Lord.
Yes.
Well, in this case, petitioner is instructed to withdraw this petition.
32 at the request of Mr. D. Google.
Lordship.
Petitioner submits that the petitioner does not express and reported the very statutory heading item. Mr.
T. Kashyap, Your Lordship.
D. Kashyap, it's
1 to 6. Deeply obliged.
May I please,
Yeah.
Your Lordship? Lordship, I like to mention to item number 10, Lordship. Lordship, kindly adjourn the matter. Lordship, matter may be taken after package.
item 10 to be listed after 4 weeks. The request made by
A. Ahmed, Lordship. On
A.
obliged.
Right, this is your lordship. Lordship, I beg to mention item number 11 of the daily list.
Yes.
May the matter be adjourned for the day.
You are mentioning on whose behalf?
On
Petitioner.
behalf of G. Portaloy.
Petitioner.
Yes, respondent number 1.
Respondent, have you informed the petitioner?
Yes, lordship.
Learned Counsel, MS Mansoor, appearing on behalf of Mr. D. Bordeloy, submit the matter 4 weeks. It submitted that consent of the council.
May I please, Your Lord? With the consent of the other side, back to mention item number 1, Lordship.
1.
1, Lordship. Already, adjournment slip already circulated.
Item 1 on the basis of the adjournment circulated, matters can be referred to instead of 4 weeks.
This is Your Lordship, on behalf of Mr. D. Sharma, I beg to mention item number 4. Kindly pass over for the day.
Item 4 at the request made on behalf of the adjournment instead of 4 weeks.
Obliged, Lord.
Yes.
Lordship, with consent on the other side, I beg to mention item number 34, the daily.
Item
34.
34. Yes, what is your prayer? What is your prayer?
Lordship, I beg to mention item number 34.
For
With consent.
adjournment, you are praying for an adjournment.
Yes, Lordship.
Oh, you are mentioning on whose behalf?
Petitioner.
Petitioner, item 34. Then refer to the request made by the council. Stop. Yes. Yes, Mr. Dev.
May it please, Your Lordship. Also, based on some allegations, Your Lordship, an affair has been lost by the wife, Your Lordship, because of some misunderstandings, and accordingly, the culminating to Your Lordship, a police case, Your Lordship, and that case I have been exonerated, Your Lordship, acquitted, Your Lordship, case 12. So what happens is that, Your Lordship, I was not even placed under suspension, Your Lordship.
Hmm.
What happens is that, Your Lordship, only 2 months increment have been stopped. So as a punishment. Because I have been served with a focus notice and I get the reply, Your Lordship, but they are not satisfied.
Yes, come and get instructed.
Lordship, issue notice, Lordship.
We are not issuing notice. Find out what's the why the punishment is imposed without imposed.
DP was proceed, Lordship. The show cause was made, Lordship.
Where is the show cause? Where is the show cause?
Page 18 may kindly be looked into, Your Lordship.
18.
Page 18.
Yes.
Notice.
Where is the reply of the show cause notice submitted by the delinquent driver?
So this is pursuant to DP.
Yes,
Pursuant to
yes,
DP, Your
Why are
Lordship.
you
yes.
saying that?
Lordship, I don't have the copy of the show cause, Your Lordship.
Your
No, inquiry office.
Because time and again, Your Lordship, I have applied for the show cause as well as Lordship.
Before whom have you applied?
To the department concerned, Your
Where is
Lordship.
that application?
So, Lordship, I have the receipt copy. Right now, I don't have any at my disposal, Your Lordship.
Get instructions, Mr. Goswami. What are you challenging? It's
So, Lordship, if Lordship allowed, then I will file an additional affidavit.
what is your prayer in the written?
Prayer, Your Lordship, is that only because I have not, because based on the FIR, Your Lordship, a criminal case has been lost against me, Your Lordship, and the wife said that because.
You have been served with the inquiry report.
Yes, Your Lordship.
You have.
No, no, I don't have this served inquiry report. I have applied for inquiry report 3 times, your lordship, but they have not furnished, your lordship.
You get the, you bring it, you show your application, whatever is there.
So, right now, your lordship, not at my disposal, your lordship. So subsequently, if necessary, I'll file an additional affidavit, your lordship.
You are asking for release of annual increment.
Lordship, two annual will stop, yes.
This is pursuant to a disciplinary proceeding,
Lordship,
some order
lordship,
has been
yes.
passed.
Lordship.
How can you make a prayer without putting a challenge to the order of the disciplinary proceeding?
Lordship, that question was put in earlier occasions, your
Then-
lordship. And then therefore, it was subsequently, after that, your lordship, I applied for copy of the copy of this inquiry report,
Then
your
you
lordship.
apply for certified copy, go and file a departmental appeal. Appellate provisions are there. You go and file an appeal.
Yes. He may file.
We'll give you liberty to file an appeal.
But instead of that, your lordship, since I have not been served with the inquiry report, your lordship, because we can,
That is what you say.
because we have been asked to furnish the inquiry report, your lordship. And therefore, your lordship, though it is not reflected in the order, your lordship, therefore you have applied for, your lordship, the inquiry report as many as 3 times, your
Yes.
lordship. But they are not furnishing, your lordship.
Possible to obtain instructions.
Even I have this.
Lordship,
receipt
the
copy.
his letter for requesting to furnish
No,
the.
no, you look into you get the instructions to find out whether after inquiry, after the proceedings, whether inquiry report was furnished to him or not. It will be there in the record.
Lordship.
Heard counsel for the party. The petitioner has challenged it is before the court praying for a direction for release of 2 annual increments of the petitioner, which will stop by order dated. So, order dated 8/10. What is the order number? Order dated 20/04/2018.
Lordship, 24/2018, your lordship.
Lordship,
Come now.
maintainability is also there. Delay access, Lord.
Counsel for the petitioners.
Lordship,
The inquiry report
only it is after the acquittal, your lordship. We have challenged, your lordship.
Lordship,
application. Under such circumstance,
Because we are waiting for acquittal, your lordship.
is not inclined to issue notice at the stage.
Hmm.
However, the government advocate is permitted to obtain instruction. Price the court, price the court, and place necessary documents required, show that, hence to whether the inquiry report, pursuant to the inquiry, after the report. Again, on 21st of July,
Lordship.
21st, extra copies be furnished within the course of the day.
Lordship, issue of maintainability.
He is not even issuing notice,
Lordship.
to raise everything.
We are awaited for acquittal, your lordship, because in
Whatever it may be, let us find out. the instructions.
2023, we have been acquitted, thereafter I have challenged, your lordship.
All right, we'll examine that.
So lordship, if necessary, your lordship will file additional affidavit,
To file,
lordship.
petitioner is permitted to file additional affidavit, straightforward, bring on record. Documents which the petitioner claims is required for a decision in the matter.
Lordship. Much of it, deep.
May I please your lordship? Lordship, my father was died on 29/11/2006.
Yeah, who's for the respondent here? There was some objection raised. Union of India, who's the appearing? CGC. Wait for some time, CGC.
Lordship, I have received the instructions and filed the affidavit, Lordship. Some time may be allowed.
Lordship, I have very limited grievances in this matter. Lordship, this matter is
That-
pending since last 1 year. I just need the information regarding that, whether how this recruitment process took place, Lordship. A date may be fixed, Lordship.
Notice not yet issued, Lordship.
Notice issued,
Well,
11,
Health,
4/11/2024.
Health Department.
submit that she is received instructions and like. Take it on. the filing. And wait for the petition. 28th of July,
Lordship.
Mobilized.
by which time it is not filed.
In view of subsequent cause of action, better inflex test.
See, from it, subsequent cause of action have been taken. Therefore, the matter has have been taken. Writ petitions then this press study courts here for the
PNRD Lordship.
PNRD department. In favor of the benefits and executed pending IAS or open.
Lordship.
Settled.
I don't, otherwise from our side, it was already settled.
Yes, settled.
Chief, we need to find our affidavit, Lordship. Only difficulty is that there's some clarification which the petitioner union would like to make, Lordship.
That clarification you make with. the
Clarification is as regards the notification. It is yet to be notified as to what would be the division of power between the company and
department.
the,
Is any clarification you seek from the department? What
and,
can the court do to
and as far as the minus is concerned, no doubt, Lordship, the AIWCL has agreed to what our apprehension is in the writ petition. But any decision in this regard has to be taken by the department. They are not our controlling authority. So in that regard, there are certain points which we would like to clarify through our affidavit, Lordship. 2 weeks time may be allowed. Immediately after the vacation, a date may be fixed. We'll file our reply.
So they have agreed and department will have to take a decision. So that is a premature case, that is why.
you take
Oh.
proceed? There is no interim order, I believe.
No, there is no difficulty for us. But if in face cause of action arises, he can always come back with a writ petition.
But he insists on filing an additional.
Whether
They have filed one
further
affidavit.
affidavit,
They have filed one affidavit. We'd like to file a reply.
reply. Mr. Putty learned counsel for the petitioner. Submit that view of the affidavit filed by the conduct department. Petitioner is under instructions to file and join the record. And the matter be listed again. So tell us when you can file
the first week of August law.
first. To be listed again.
First, Lordship, I have some difficulty. Second, first I will be out of station. Let it be 4th or 5th, Lordship.
4th or 5th.
Any day.
4th,
Lordship.
4th of August, by which time the returned affidavit as written may be filed by the
Deeply obliged.
third, with the 20th, date, filed by the court.
May pleasure. The petitioner praying for compassionate Lordship. Although Lordship, petitioner filed a petition, Lordship, before the cut-off date, Lordship.
You
but
mentioned some IA was filed.
Lordship,
That
it
IA,
was,
according to
it
the
was,
office-
it was wrongly submitted, Lordship. I apologize for that, Lordship. Additional affidavit filed, Lordship. Not IA, Lordship. Challenging the impugn order. Lordship.
In terms of the earlier order, dated 16/6/2025. Direction was issued to the region. This identification along with the IA. You had given the number of the IA also. IA number
Lordship.
109,
Lordship, repetition number is given, Lordship.
IA in the pending petition. When the matter is listed, counsel will submit that he had inadvertently submitted to the court regarding the filing of the IA. But instead, what was filed was an additional affidavit. And it is already corrected. Here. You are agreed by which order?
Lordship, by the notification, Lordship, that has been challenged, Lordship,
You are challenging the notification.
Lordship. Lordship, in this case,
Commissioner has brought in the notification dated 18/9,
Lord,
2024. But by way of an additional affidavit, you can bring it on record, but for challenging, you'll have to take a proper course of action.
Amendment is required, Lordship.
We can't advise you what you should do, but
Lordship,
bringing it on affidavit, record by way of
Lord.
an affidavit is okay. That by itself does not mean you are putting to challenge,
Lordship,
because there is no prayer for setting aside.
Lordship.
All right. You think
Lord,
and come back.
Lord,
The prayer made, the writ petition now is for a direction to set aside. The notification dated, interfere with the notification dated 18/9. Our order is to take a copy, additional senior government, on the other end submits that there is no specific prayer in the writ petition regarding the challenge made. So, that view of the matter, council commissioner pray for some further time to complete his practice, which the matter after 4 weeks.
detailed.
Please, your lordship. Actually, later maybe on time being lordship.
You get instructions. This is a, they've challenged the continued suspension.
Yes, please.
Get your instruction.
Lordship.
Third council, the petition. Or to this court. Challenge the suspension order. Impugn suspension order taken when whereby the
Lordship, here in this case, he is the home guard, Lordship. Suspension is not there.
I don't know,
He is the home guard, Lordship.
it's what they're saying. Verbal
And
suspension order.
impugn, Lordship.
The verbal suspension order.
Lordship,
Get instructions there.
Lordship.
That-
Notice may go, Lordship, will submit our reply.
No, we don't want to issue notice. To find out. Get
Lordship,
instructions.
Lordship.
Court is not inclined to issue notice at this stage. However, the state respondent is permitted to complete his instructions in the matter. Extra copies we furnished to the government council today. If not already furnished. Please after reopening.
Obliged, lordship.
Please, your lordship. And the petitioner was appointed as rifleman on September 2017 after passing all the examination and after necessary verification. However, my lord, during training, he was dismissed suddenly, my lord, on the ground of submitting false document. He did not get any opportunity, my lord. I am paid notice.
Dismissal order.
Yes, my. Please 18.
Have you filed any appeal?
Yes, madam.
Review or revision?
No, my lord, appeal is pending, my lord.
Appeal is pending.
Yes, madam. They have not given. So,
It is of 2018 dismissal lordship. As per dear person 2001.
You get instructions, what has happened to the appeal?
Yes,
Yes.
lordship.
Third council. Writ petition is filed by the petitioner who was employed under the Assam Rifle. And on the ground of submitting fake and false certificates at the time of enrollment, petitioner was dismissed from service on 17 February 2018. So again, state dismissal order He prepared an appeal dated 5/10/2021. He submitted that the said appeal is still pending and no decision has been communicated to the petitioner as on date. The MS R. David and CDC is prayed for 2 weeks time, 3 weeks time to complete the instruction. As to the status of the appeal prepared by the matter, it is dedicated up to 30 July. Extra copies be furnished during the course of the day. There are is
May it please the Lordship. My lord, petitioner is working as inspector in border security force, my lord. He is, when he was on duty, my lord, he was beaten by commandant, my lord. For that, he has got injury. Well, inquiry was conducted. Kindly see page 31, my lord. Page 31. Administrative action to be initiated against that officer. That is okay, my lord. Then next, my lord, my lord, injury is not attributable. They have held page 31. So I am aggrieved by this, my lord. Notice may be issued.
then what happened after the medical board?
Nothing, my lord. Then nothing has happened.
What do you think? You were asked to be placed before the medical board.
That was not done, my lord. And this copy was also served to me in 2024.
They appears. And it's appeared for all the respondents. And such is the way for our extra copy furnished. Sorry, respondent 1 to 6. Therefore, the way our extra copy furnished. The date. Steps of respondent 7 by registered committee as well as legal courts within 1 week. And to be listed after 4 weeks.
My lord, with due respect, my lord, with due respect, my lord, bring notice upon private respondent number 7.
Yes.
If I have been instructed this,
You are appearing.
on behalf of respondent number 7, but I will file my Ukalatnama within a week. He is in Chandigarh. I will file a Ukalatnama within.
So that council has instructions to appear on behalf of respondent 7. She submits that she be permitted to file her power within a week's time and the respondent 7 is present state in Chandigarh
Chandigarh, ma'am.
and he has already dispatched a people side Bahalat. Forward. Yes,
My lord, I may be served with a copy.
petitioner will serve extra copies on all the respondents.
Oblige, my lord.
Please, your lordship. Lordship, my senior lacks in another good. Can be faster for time? Time being lost.
We'll issue notice then.
But-
We'll issue notice.
Lords-
But take
Lordship, I am on behalf of Lordship 1, 3, and 4, Lordship. Other rest, Lordship.
or five, 6, 7. With all the respondents that are with the way please be furnished within 1 week from today. On the current council. Respondents are at liberty to file their
Lordship,
affidavit.
I am on behalf of 1, 3, and 4, Lordship. Rest, Lordship, M. Kotoki, Lordship, standing council, Lordship.
Lordship, 15 similar matter. 15 similar.
Similar matter. But this is agriculture, similar, not veterinary,
Similar.
not veterinary.
But it is agriculture.
But
Respondent number 2.
noticed. Taking authority and it-
1, 3, and 5.
It's yeah, 1, 3 and
5, Lordship.
5 or 4.
Lordship, sorry, 4, Lordship.
1, 3 and 4.
4, Lordship.
MS
5, 6, 7.
appears for respondents.
2,
number
5, 6, and 7.
2,
2, 5, 6, and 7.
5, 6 and 7. Extra copies be furnished within a period of 1 week. Or between the State Council, respondents may file their counter affidavits in the meantime, with this after 4 weeks.
It is your lordship, my lord, this matter relates to compassionate appointment, my lord. Here, the petitioner's name was already recommended by the GLC, my lord. It is at page, my lord, page 31, my lord.
What about the notification?
My lord,
Notification, it
yes, my lord. Subsequently, his case name was also included in the list prepared for placing before SLC. And thereafter, this office memorandum was issued. So we have challenged this also, my lord. So subsequently, in the series of writ petitions were filed challenging the office memorandum. And there was a final order dated 3/4/2025, which I have annexed, my lord. And thereafter, another order was passed regarding pending cases in the department, my lord. This is squarely covered by,
This is
this is
applicable to
the-
only cases pending on 3, 4,
my lord.
Yes.
Subsequently, there was another order.
another order.
Yes, my lord.
Have a look, Mr. Goswami.
This is regarding the, my lord, similarly situated cases pending before the department.
Is the consent of the parties, Lordship.
No, my lord,
This was given-
your lordship may kindly peruse the last paragraph. Here also, the petitioner's case was pending before the department.
Yes, what do you say?
Notice may go at this stage, Lordship.
Notice,
Yes, Lordship.
why this writ petition should not be closed with this order?
And that is in consenting one, Lordship.
Where is
Parties
the one?
consent.
No, there is no consent.
Yes, Lordship, the paragraphs is specifically stated, Lordship. In the, I think,
Last paragraph behind.
that observation was given after consent the parties, Lordship.
No, my lord, it was
Second order.
disposed of with the motion
There is no
stage.
consent.
Lordship,
You may have a look.
yes.
He missed.
Excellent. Lordship, paragraph 10, it is made clear.
Where's that?
it to hit
Four with it.
ঠিক আছে report করে দিতে।
Consent.
Yes, Lordship, I will.
What I meant was of the view that urgent order, although directed to be not treated as a precedent,
Yes, Lordship.
contains certain direction,
Yes, Lordship.
which the court finds that be applicable to that. The petitioner report the valid to the DLC and recommended the point. But they are considered in the seal ground. Indication dated 18/9. It's that. But the challenge was made.
Yeah, Lordship. Lordship,
Reported by the deep case was reporting. After referring to a subsequent order passed by another court and then commits that this the earlier court and bench order
petition আগত ফাইল কৰা নেকি নে no 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 এইটো পিছত এইটো
therefore submit that this fact of the similarly wait similar order and right that became from the Part B
martial obedience
and and not within B 5 6 7 8 jointly submit that the earlier orders passed by the court and bench did not settle. They may be perfect sometime that view of the notice issue. Very quick notice.
Lordship.
4 weeks. The respondents are represented by you give back the copy of the order.
Lord, yes Lordship.
It's up.
Similar man.
Similar. They both.
May I please, my lord, at page 53, my lord, the petitioner was placed under suspension under my lord 61C, my lord. In the last occasion, they have been asked to take instruction, my lord, whether mandatory review was done or not, my lord. And no departmental proceeding also been initiated, assumed. 53 lordship can have a look.
Yes, review.
Yes Lordship, regarding review Lordship,
With the review done.
Yes, Lordship.
You are receiving your subsistence allowance.
What's pricing? No, pricing, no?
What's
Yeah.
Lordship?
Yeah, but yeah.
Review was made.
Fairly covered case is, my lord, Jonah.
Copy appears for respondent one.
Yes, Lordship. I am
And respondent number 3 and
1 and 2, Lordship.
2 is final.
So, 2, Lordship.
1, 3.
What was that?
4 district courts. Lordship. No, Lordship. I am on behalf of 3 and I am on behalf of Lordship 3 and 4, 5, Lordship.
3 and 5.
Yes.
Who is for 4? Director of
Or
accounts.
I'll be appearing.
3 and 4, Mr. J.K. Gupta, Mr. Kolihai, here for respondent.
1, 2, 4 and
1, 2,
4 and 6.
4 and 3. Then account representing. Okay. The respondent completed instruction and right report. And but whether it is new was undertaken. Respect to the suspension order of the retention,
Exam.
whereby he was placed
10
in
February.
suspension by order dated 10th of February 2025. The respondent will apprise the court of the pick. It's not 16 July.
Lordship.
On that day, my lord, endeavor to be made to was of.
Subject to instruction.
Yes,
given.
Lord.
otherwise this case is covered by the government,
Is it?
squarely covered.
Then doesn't.
Yes.
It is for disciplinary proceeding.
My lord, suspension was there, my lord. suspension
Maybe
has
for
been said.
disciplinary proceeding, then
Suspension was,
there was a minutes for reviewing of the suspension order.
but here also review was not done, my lord, accordingly.
Who is it covered, Mr. Burma?
So
Merely because the word suspension is there doesn't mean it is covered. That could be a- It's on 16th.
Last.
Lordship. Lordship, in this case, I faced some time, Lordship, because the judgments cited by my friend, Lordship, para 37, Lordship, in that judgment, Lordship, kindly see that direction given by that court by para 38, it was given, Lordship. May I read, Lord? Para 38, in case of wrongful termination of service, reinstatement with continuity of service and back wages is a normal rule. The aforesaid rule is subject to the rider that while deciding the issue of back wages, the adjudicating
So
authority
you are
of
reading.
para 38, the proposition which can be called out in that
Which judgment?
Dipali Good
Dipali.
Lordship 2013 10 SSC 324, which my friend realized, Lord.
Oh. What is the
There is the paragraph 33, perhaps in Lordship.
30? Yes, propositions.
The proposition. In case of wrongful termination of service, reinstatement will be continuity of service and back wages is the normal rule. 38, the aforesaid rule is subject to the rider that while deciding the issue of back wages, the adjudicating authority or the court may take into consideration the length of service of the employee workman the nature of misconduct, if any, found proved against employee workman, the financial condition of the employer and the similar other factors. Ordinarily, an employee or workman whose service are terminated and who is desirous of getting back wages is required to either plead or at least make a statement before the adjudicating authority or the court of the first instance that he or she was not gainfully employed or was employed on lesser wages. Here in our case, Lordship, there was already an order of reinstatement without back wages, which was affirmed by the division bench. And without challenging that order, Lordship, whether he can come and whether this court can set on an appeal, Lordship. Because there was an order of reinstatement with back wages.
What is it that you're doing it? What is the direction you are seeking?
I was seeking notional benefits for the period when I was kept out of service. The order of this honorable court already
Where is
having
the division bench order?
It was our appeal has been dismissed.
Where is
That
that
means
order?
to put fine. Should put fine the disposal order at page 36 onwards, my lord.
See what?
And at page 41 para 10. When the matter is being
Page?
page 41 is the relevant portion of the writ appeal, of the writ petition.
41.
The writ appeal order is there. Para 10.
Okay.
When the matter is being given its final consideration in the appeal, the appellants could not produce any reasonable ground as to why this court should differ with the conclusion of the learned single judge in his judgment and order dated 10/4/15. It is noticed that the entire basis of initiating the disciplinary proceeding against the respondent and also in arriving at the decision to remove the respondent from service was the opinion of the Deputy Commissioner upon verification that the respondent belonged to the OBC Yoginath community and he does not belong to the scheduled type post-classroom community. This court does not find any reason to differ with the view taken by the learned single judge that the basis of arriving at a conclusion as regards the correctness of a caste certificate produced by the respondents would have been verified only by the high power committee constituted pursuant to the direction of the Honorable Supreme Court in Kumari Madhuri Patil's case. And the basis of such conclusion could not have been a verification report by the concerned Deputy Commissioner. It is further being noticed that a specific stand of the respondent he was appointed as a general category candidate by satisfying its qualification requirement and he was not appointed on the basis of such caste certificate. No material has been produced by the appellant to controvert such a stand of the respondent. In view of the above, the appeal is found to be devoid of merit.
And
And
what is
see-
the finding of the single bench?
page
single
24.
bench-
Page 24, Lordship. Page 24, para 34. Thus, it is evident that the procedure laid down by the apex court in the case of Kumari Madhuri Patel Supra has not been following in the present case, which has reshifted the decision-making process, culminating in the decision to remove the petitioner from service. That way, accordingly, and in the light of discussion made above, the impugn order of penalty dated so-and-so as affirmed by the appellate authority on so-and-so cannot be sustained and hereby set aside and quashed. Petitioner is directed to be reinstated in service but without any back wages. And this was affirmed by the division bench.
Not asking for back.
Not a single
Not back wages, but continuity in service. Kindly see the impugn order, Lordship. What we have done after this
Page number?
is non-coming, Lordship. Page number 31. And operative portion, Lordship, it will be from page 32. Page 32. In view of the above, I understand hereby set aside the punishment of removal from service imposed upon so-and-so, so-and-so, commandant so-and-so, dated so-and-so, and he is hereby reinstated into service with immediate effect in consonance with the order dated 25/1/2000 passed by the division bench of Honorable Guwahati High Court in writ appeal number so-and-so. The reinstatement of so-and-so is conditional subject to outcome of the writ appeal because at that point of time, writ appeal was pending. On his reinstatement, he is posted in so-and-so, so-and-so. He is also directed to report on so-and-so battalion CRPF within 15 days from the date of receipt of this order. he is not entitled for back wages, that is from the date of removal from service till reinstatement, as held by the single bench of the Honorable Guwahati High Court by the order dated 10/4/2015, passed in writ petition so and so. The intervening period, that is the date of removal from service till reinstatement, is treated as period not spent on duty. However, the above period is known for the purpose of pension under Rule 25 of CCS. What wrong? It is consistent with the single bench order. Without setting aside that order, Lordship, how can the continuity in service seniority will be given to him, Lord?
Then what meaning do you ascribe to the term reinstated?
Reinstatement, it was reinstated without wages.
Back
That was a
wages.
specific direction,
No, is there no difference between reinstatement and fresh appointment?
Lordship.
What is the meaning of reinstatement?
Reinstatement, Lordship, as in
He is
Departmental
directed to be reinstated.
reinstated
Back wages.
without back wages,
So you don't pay him back wages,
Lordship.
but you reinstate him.
Reinstated,
Once you reinstate, he is entitled to all service benefits.
Lordship, that their pleadings should be there for continuity in service, Lordship, that
for back
2005, Lordship, that judgment I have given, Lordship. That 2005-6 SSC 36.
Let me go. Hold it down bit.
Para 11, reverting to the facts of the case at hand, as already noticed, the Labour Court specifically directed the reinstatement would be without back wages. There is no specific direction that the employee would be entitled to all consequential benefits. Therefore, in absence of specific direction in this regard, merely because an employee has been directed to be reinstated without back wages, he cannot claim the benefit of increment notionally earned during that period, when he was not in duty during the period when he was out of service.
It would require some hearing.
Lordship.
Just take.
Heard. Counsel for the party. Yeah. Reopening. Give us the date, convenient.
Convenience of the public.
22nd of July. That is to be treated as part.
Obliged.
Lordship, let it be on 24th.
Before
Lordship.
like 24. 24 July. I'll just come back in 2 minutes.
Lordship.
On the last date, as we can see,
Which case, Lordship? This case,
this matter, the last order 2110,
Lordship.
some objection was raised on the ground that it is not maintainable. But why is it not maintainable was
Central Administrative Tribunal.
central. Do you have that circular?
Lordship, administrative, that book contains, Lordship.
Administrative packet of that. Central administrative.
Some administrative.
Yes, do you have it?
No. Lordship, in this, the appendix portion is not here, Lordship.
Get it?
Lordship,
You get it from your office?
Lordship.
We'll pick it
Lordship.
up at the end of the list. This is the matter has to be filed before the
Central Admin.
Central Administrative Tribunal. Okay. Are you aware of that?
In terms of section 14,
Or-
in terms of section 14 of the Central Administrative.
Towards 14. What is the challenge you are making here? Professional appointment.
Yes, Lord.
Petitioner is grieved by on consideration of our application for professional appointment. Okay. It is important. Right. Referring to section 14 of the Central of the Administrative Tribunal Act 1985. Submit that the matters for recruitment and concerning recruitment to any civil post under the Union are to be filed before the Central Administrative Tribunal. Since the petitioner is seeking professional appointment. Under the office of the Chief Postmaster General of the matter is covered under section 14 and therefore required to approach the Central Administrative Tribunal in the first instance. That restrictions counted to the petitioner fairly submits that he would like to withdraw the writ petition with liberty to approach the Central Administrative Tribunal. Prayer made is allowed, writ petition stands dismissed with liberty to approach the Central Administrative Tribunal. Respond. Yes.
William. It is Lordship. Lordship, in item number 20, service report is awaited in content.
20 await service report.
Lordship, I have a small prayer also.
Rest of the matters, Lordship, may come up immediately after the vacations. Here, DYSJ is leading us.
Who?
DYSJ.
Yes.
Read him.
In the other matter, learned it submits that. Have you filed your counter?
You already filed.
It that since the counter affidavit has already been filed and the deputy solicitor general of India, which represented the matter be listed immediately after the opening. Mr.
K. Kolita on behalf of KK Product.
K. Kolita, here's the
Number
KK product.
92 series.
item number 21.
That you give it, get it with the court martial. That will be listed in the first week of August on a date to be fixed by the registrar. Okay. Yes.
New incumbents were impeded, notice by who? I think that, but
You have filed some IA for impeachment.
It was allowed by Lordship, and then the amended cost title was also filed. Lordship, the notice may go to the new incumbent.
Who are the newly implemented respondents?
Lordship, there is the amended cost title. There were four officers.
You have filed the amended post title.
Yes.
Since amended post title has been filed, showing the array of parties, the duty completed respondents, the complete scope, respondent, what steps be taken by the authority as well as civil courts within 1 week from today. Mr. Talukar, if you.
For five, my lord.
Here's the respondent.
Lordship, but direction was issued to the forest department only, Lordship. We have unnecessary English.
This after 4 weeks.
Praying for review of the order at page 118 mil. What actually has happened, my lord, there were two petitions, my lord, tagged together. When your lordship has disposed the WPC 5961 2023, so in inadvertent level of the facts of that petition has been recorded in this in 6246.
We did some corrections, I think, in one matter. What?
That was corrected, my lord. That is in 59, some IA was filed, that is corrected. Now here, my lord, in this 6246 was in respect of supply of promels. Now 5961 and 6246 was in respect of segregation of legacy waste. My lord, the work orders were different.
So
what
is the error apparent?
My lord, the page 119, your lordship will kindly see.
Yes.
The third paragraph,
Hmm.
the respondent authorities have issued a work order dated so and so, work order number so and so, petitioner was awarded the work for supply of promels on higher basis in capacity of 300 MT per day with 75 through 100 mm of screening rate, and rate offered by the petitioner was declared as the lowest quoted bidder in terms of condition in respect of the use of promels, and the payment thereto are specified in the work order itself. Now, my lord, your lordship will kindly see page 54 is the work order. Page 54. The work order involved in that repetition is, my lord, 22/12/2020. It is work order for RFP for segregation of legacy waste using trommels and other allied infrastructure and manpower. This was.
What is this segregation of legacy waste?
My lord, the waste which is dumped there, my lord, it is put into the trommel and it is segregated. The legacy waste is segregated, and the waste which can be used, these are segregated, my lord, by the trommels. So this work order was for segregating three.
So there were two work orders. One was for supply of
Trommels and one was for segregation of peat.
So in this writ petition 6246,
we were concerned about the
segregation.
And the issue involved in that writ petition was that after the work order was issued, page 83 was the completion certificate.
Yeah.
Page 83, time to time after a amount of work is done, a completion certificate was issued. This is the final work, final certificate, acknowledging that the entire work order was executed. And thereafter, page 84, there was a letter also issued by the authorities to the petitioner saying that as the work is completed, he was asked to remove the machines from the site. Thereafter, the bills were not being paid. Therefore, we filed this petition. So now the order which was passed in this petition was considering the fact that is of 5961 of 2023, but that is page 123.
So only the nature of the work and
also the submissions that was made by the respondents, that was which has been recorded at page 120. That is also in respect of the submissions made in 5961 of 2023. Because 5961 2023 was a supply of promels of higher basis, where for a period the bills were not paid.
now regarding the minutes of 18.7,
That is for the promels, supply of promels.
is there a similar minute?
No.
Yes, Mr. Bora.
My lord, I have no objection. The lordship will have to, that writ petition had to be restored, my lord. If lordship wants to recall that particular order date, this order dated 9/4/2024. It is completely separate, different.
No, but the submission, if I recollect correctly, was
No, well, what had happened, my lord, on that particular day?
release.
Yes, my lord, on that particular day, that other writ petition was taken up first, my lord. Then they said it's similar matter, with similar issue, my lord. Then same order was passed, my lord.
About the errors may have crept into the
Lordship.
We want to know is that subject correction. What we recollect is that FCS says we have taken the decision to release
No,
the case.
that is, decision was, my lord, lordship had quoted the decision, my lord.
That is only in respect of one.
One, my lord. And for a certain period, my lord.
One, the
Promo,
supply of
promo.
promels.
Supply of
Promels, my lord.
In
Lordship
this-
had quoted it, my lord.
In this, there is no decision.
No, there is no decision.
But ultimately, they are entitled to the bill.
They are entitled
Or
to
is
that.
it disputed.
No, affidavit has been filed when a certain decision has been taken in a different, objecting that they are saying that they have not supplied this, they have not done that. Well, that affidavit had all been filed, my lord.
But review petition is filed seeking review of the order dated 9/4/2025 passed in WP 6246 of 2020 by the said order on the submissions made at the bar as was given as was as the court was given to understand that that both the writ petitions being WPC 6246 2023 and WPC
5961 of 2020.
5961 of 2023 filed by the same writ petition can be disposed of as the DMC authorities have taken a decision for release of the bills. So, WPC 5961 2023 was filed by the petitioner to challenge the non-release of the bills in respect of the work order issued to the petitioner for supply of promels, TROMMELS, on higher basis in the capacity of 300 metric ton per day with 75/100 mm of screening, at the rate offered by the petitioner, who was declared to be the lowest quoted bidder. The works were duly completed, and however, the bills were not released. Subsequently, there was a decision taken by the GMC authorities, findings of which was extracted in the order, whereby the GMC authorities had agreed to clear the bills in respect of the writ petitioner for the work allotted for supply of promels of higher basis, a capacity of 300 MP per day with 75/100 mm of screening. Since WPC 6246 of 2023 was also taken up for hearing, and submissions were made that in both the writ petitions, the GMC authorities had taken a decision to release the bills. Both the writ petitions were disposed of. However, in the order dated 9/4/2025, passed in WPC 6246 of 2023, which is presently under review, the work order quoted, was wrongly quoted. Instead of the work order, where is that work order?
Page 54.
54. Instead of the work order, numbers so and so, page 54 to 9, dated 22/12/2020 for within quotes until the underline for asset in italics quotes was required to be quoted. Stop. That apart. The completion certificate issued to the work completed by the petition in respect of the same contract was also issued. It is submitted by the counsel for the parties to this court that the decision for release of the bill was only in respect of work order dated 22/12/2020, ID work order number so and so, paragraph page 119, third paragraph. For the work supply of bills on higher basis in capacity of 300 MP per day with 75/100 mm. So there was no decision taken by the GMC in respect of the work order for segregation of legacy waste, like trommels and other allied infrastructure and manpower, which is the subject matter of WPC number 6246 of 2020. That view of the matter, the order dated 9/4/2025 requires correction. The same is therefore before the writ petition WPC so and so 6246 of 2023 accordingly restored to 5. The petition allowed, disposed of the writ petition instead after 4 weeks. For hearing or
Admission. Grateful man.
It please your lordship. The I is filed for imprisonment of the wife of the petitioner, as the petitioner died on 9/11/22.
Only wife, no children.
He has a daughter, but the daughter is married and not interested in the matter.
Third counsel in the IA. Third counsel for the parties which submitted that the writ petitioner Sarifa Kali has passed away during the pendency of the writ petition. Accordingly, the widow of Sarifa Kali, being the applicant in the IA, has filed an application for substitution of the heir. It submitted by the learned counsel that late Sarifat Ali left behind his widow, the applicant, and one Madhuri Rasu, who's the daughter. The daughter is married and working as a subject teacher, and therefore is not willing to include herself in place of her deceased father. So, this statement in the IA is sworn in an affidavit stated to be true to her knowledge of the other. Any objection to substitution? No. Mr. K. Moore, additional lady appearing for the PNRD department. Mr. Leader on behalf of the last appearing on behalf of Mr. P. Sharma for Accountant General. Does not object. Accordingly, I stand allowed. The applicant may be so and so is allowed to be substituted in place of Sarita Kali, late Sarita Kali. The writ petitioner in WPC 1347/2025. Counsel for the applicant will file amended course title to the registry within 2 weeks from today. IA accordingly allowed to dispose of. Copy of the IA be retained in the case record of WPC 3181/2022. The writ petition you write in view of the order passed in IA number 12. In view of the order passed today, the IA number 12. The applicant and so was permitted to be substituted in place of late Sarifat Ali. The petitioner in WPC 31812, who is stated to have expired during the petition. Petitioner will file amended course type. Matter be listed thereafter.
May I please your lordship. The impugn office memorandum dated 18/9/2024 issued by the Commissioner and Secretary to the Government of Assam, Personal Bill Department, by which it has been decided that no cases for compassionate ground to place before the DLC or SLC for its appointment. At the time of filing of the connected writ petition, the applicant inadvertently did not make the Commissioner and Secretary as party respondent as respondent number 6, for which I have filed the instant in IA.
Any objection?
No.
Heard counsel for the applicant. This IA is filed for improvement of the Commissioner and Secretary, Government of Assam, Personal Secretary, Department is 6. So it is submitted that the accompanying writ petition, the WPC 3121. The petitioners, inter alia, have prayed for setting aside the office dated 8/9/20 by the Government Secretary, the Government of Assam Personal Department dispute. However, at the time of filing the writ petition, by oversight, the said department was not arrayed as a party to the court. Therefore, present IA has been filed. Learned government advocate, MSK Kaluta, does not oppose the prayer made. In that view of the provision, the matter of the IA extends allowed without issuance of notice at this stage. The
I'm for respondent number 4 only, Lordship.
Commissioner and Secretary to the Government of Assam, Personal B Department. Dispur Guwahati 6 is arrayed as respondent number 6.
6 to implement
The writ petition 311 of 2025. Stop petitioner applicant will file amended post title within the registry within 2 weeks from today. I accordingly allowed dispose of in the accompanying writ petition derived in view of the order passed today in IA number 1910. Commissioner and Secretary, Personal B Department, Government of Assam is arrayed as party respondent number 6. Stop. Let notice, let notice issue on respondent number 6, MSD Talukdar, a government advocate, appearing has entered appearance on behalf of respondent 6 as well as respondent number 4. Completely permitted time to complete the instruction and by necessary affidavit is to advise in the meantime. It's after 3 weeks.
Highly obliged.
That's Lordship.
It will work. If I file this application for a permission for a direction to the authority to allow me to sit in examination in the APS exam conducted by conducted for 50 numbers of posting in junior engineer law, the PWT. Lordship, what happens? Last 2 minutes back, I come to know that the copy of this IA has been served to my the council of the opposite party. So I'm serving it today. Now it should better be taken up tomorrow, Lord.
You allow us to participate.
No, we cannot, my lord. Lord and none does not permit, my lord. Your lordship kindly see, my lord, what he is doing, my lord. My lord, the motion stays, your lordship, I let him submit, my lord. No, copy I have been served to me, my lord. Lordship kindly see after finding of last date. Your lordship kindly see his overage, my lord. Overage candidate, my lord. And he, my lord, after 3 days, my lord, going to hold on Sunday, my lord, going to hold my lord skinning test, my lord. There's a written text, my lord. And he is sleeping over the matter for last 3 months, my lord. Your lordship kindly said the last day of filing was, my lord, over by the month of, my lord, February.
Why were you not filing?
Lordship,
after 2 months, 15 days, he has filed this petition.
The order rejecting my permission for consideration of case was rejected on 19/6/20, just 2 days before. Lordship, I filed the petition earlier. I was waiting.
Passed by who?
It was passed by your lordship. Deputy Secretary of the Government of Assam, Establishment Confidential Paper. My application was rejected on that day. Therefore, I'm challenging this in this petition by filing one addition amended petition, amendment petition I have filed, and I am praying for that.
But what is the point in appearing for the examination unless there is a written?
My prayer is that as an interim I may be allowed to speak in the
First, you satisfy the court.
Yes, Lord.
That the rejection was prima facie appears to be bad.
Actually, Lordship, what happens that rejection, I am filing the application for amendment. That is to be allowed, and then only it will come in the repeat. So, I may be.
Without that, how do we take up your IA with a liberty?
Lordship, this IA, my prayer is that I will be allowed to sit. Whatever will be after the rejection.
You must make out a prima facie case that the rejection on the face of it appears to be incorrect.
Lordship, this rejection, Lordship, there are several judgments of the Honorable Court whereby this some petitioners were allowed, some persons were allowed. There are instances, various instances whereby the court allows the petition. I can show that petition if you Lord permission, but today I am not ready with that because I was expecting that this petition will be released with permission petition. Therefore, my petition still have life. Therefore, my prayer is that I may be allowed to sit in exam. Whatever happens, whatever will be the result or whatever the outcome of this petition, I shall obey by that. But
what examination is this?
My lord, I'll please. Junior engineer civil, my lord. Junior engineer civil, my lord.
What? Written?
Written.
Written exam.
Written examination, my lord. I'll just place one thing, my lord. My lord, today what he stated, I don't know, my lord, that petition is yet to be filed. What happened? Your lordship kindly see the main petition, that petition, what is his pair? His pair is, my lord, allow the petitioner to apply for the post. My lord, after filing of the last day over, the last date of filing is over, my lord, 4/3. He approached this honorable court after 2 months, 15 days. After 2 months, 15 days, he came to the court, yes, I may be allowed to fill up the form, my lord. Can it be, my lord? That's why, my lord, in the time of my lord motion, my lord, it was reluctantly, my lord, issue notice, my lord.
Petitioner was waiting.
Now, my lord, he says that I may be allowed to sit in the examination, which will be going to be held on Sunday, my lord. All over Assam, my lord, in different, my lord.
Why did you not pray for, make the state prayer in the writ petition?
At the initial stage, it was not granted, my lord. Now, by way of my lord Miss case, he says that I may be allowed to sit in the examination. He has not even.
Prayer was not made on the last date.
Lordship, by this amendment, I am saying that the cancellation order may be allowed. That I have made. But
When were the dates for examination announced?
it is on 29.
When was it announced?
It was announced, Lordship.
28 May.
Then why did you not make a prayer?
I filed this application on 16.
Who has rejected it?
That condemnation.
Who rejected
It
it?
was rejected by the Deputy Secretary, Government of Assam.
From which department?
Evans PWRD.
DWR.
Yes, sir. I shall open whatever of the requisition.
What is the difficulty if you allow him to sit?
There is a difficulty, my lord. So, first of all, my lord, he has no prima facie case, my lord. Second thing, my lord, we cannot change it, my lord, because, my lord, this is too late, because it is a written examination. Question paper has to be set there all over Assam, my lord, in different examination center, it will be held, my lord. And, my lord, it is not the, my lord, law is not permitted to, my lord, sit in the examination, my lord. Because my lord, he is yet to fill up the form, my lord. He is not eligible to fill up the form, my lord. He has yet to fill up the form, my lord. Whole process has been completed, my lord. Now we are only, my lord, just to, my lord, distribute the, my lord, already, my lord, question paper also, my lord, everything has been, my lord, distributed to the different center. Your lordship kindly see how many center, my lord, that will be held, my lord. It will be held in different center, my lord, in Assam, my lord. That is, my lord, about 6 center, my lord.
Not filled up the form.
Your
form is not been filled.
His prayer is to, my lord, fill up the form, allow him to fill up the form.
In the
Lordship may see, I'm providing.
And that prayer was made after last 2.5 months of the, my lord, last date of my file.
Anyway, you have not filled up the form. You have not made a prayer for allowing you to permit. When the matter was last heard, it was, last order was on 23/5.
Yes, sir. Lordship may see my application to the authority was on 27/1. That was rejected on 19.
Why will you not make this prayer that in the event that the application is not allowed, you should be permitted to sit?
That
These are not made.
Yes.
We'll issue notice here, let us see what. Third counsel for the party issued notice in the IA. Mr. T.J. Montol and the counsel, Mr. S.P. Sharma, appears for the PNRD, Mr. Nair, appears for the PWD. Is accepted by M.S.P. Sharma. The APH.
Lordship may, there is a prayer B.
And
A writ of mandamus.
Nair for the PWD. Yes.
A writ of mandamus directing the respondent APSC to
Prayer
allow the
B where in the IA?
No, in the main writ petition.
In the writ petition.
Yes. A writ of mandamus directing the respondent APSC to allow the petitioner to apply for the post. As a
So, but
specimen.
you did not make this prayer on the day. when
Yes,
the
that was not
petition
allowed,
was
my
moved. You should have made this prayer.
On that day I did not, because
You did not. So
It remains, and notice of receipt means.
Now you are yet to fill up the form. I can understand that you have filled up the form.
No, Lordship.
Admit card is not issued, is a different issue. You are yet to fill up the form.
That is not allowed, Lord.
Returnable after 4 weeks.
Develop.
We should sit together with the IA. Respondent may file their objection in the meantime.
Develop.
If required, we'll pass appropriate orders. Let us take.
Yes. Oblige.
My lord,
Respondent
here,
file affidavit, yes.
Lordship, here we have already sent a letter to the elementary department, Your Lordship. Actually, the secondary department has no role in this
Who
matter,
is
Your
the
Lordship.
elementary, who's for elementary education?
Lord-
What do you say?
Lordship, in last two occasions, secondary council took time to file affidavit, but the letter shows that it matters pertaining to elementary department.
So you don't want time.
So, Lordship, I want time,
You
after
want time.
vacation, Lordship.
Lordship, may kindly come to the page number 29, Lordship. After that, there is no development, Lordship. This was the observation made by the Accountant General, Lordship.
Let her get the instructions, Mr. H. Sir for the petitioner. Mr. Ranki for secondary education, MS
Videka.
Videka for elementary education.
Elementary.
Carry for respondent 7. The Council for Elementary Education renews their prayer for time. Complete her instructions. The matter being the writ petition has been filed for release of the service benefits as well as arrears of pension. Matter be listed on 16th of July. Get your instructions.
Right.
Based on 16th of July.
Obliged.
Chief, Mr. G. Portolo is down with severe vertigo, so he's not available in the board. However, he will provide the necessary up-to-date instructions. Let the matter kindly be fixed after vacation.
Yes, on the request made on behalf of Mr. G. Bordoloi, Counsel for the Corporation Department, matters have deferred to be listed after vacation. The Counsel for the petitioner does not take to the prayer mail list on 21st July. Yes.
Right.
But in the case, Malat, already district level recommended and state level also considered, Malat. Lordship, kindly have a look at page 39, Lordship, of the SLC, Malat. Yes, page 39, Malat.
Yes.
The SLC held on 13/9/2022, Lordship, page 34, and the relevant portion, Malat, 39. Malat, para 9, Lordship. Last, this 39, last para.
Yes.
Against the list of recommended candidates by the DLCs after rejection of a candidate mentioned above, the following 33 candidates remain for consideration in grade 4 post. Here, Malat, my number is 1, 2, 3, 4, 21, 23, Lord. People Rava. And Malat, here, as per the clause 10, my Lordship, kindly have a look. Now, out of 33 persons, the candidates, following 22 candidates are recommended for appointment on compensation ground in grade 4 against the earmarked vacancies. Now, up to 22, Lordship, next page 42. Up to 22, they have been already recommended and appointed. My serial number is now at serial number 23, my lord. Lordship, kindly have a look at page 43, Lordship. 13, Lordship, clause 13. The remaining 11 numbers of eligible candidates proposed for grade 4 post, along with remaining 3 candidates proposed for grade 3 post 2014, can it shown below herein below could not be recommended due to non-available of sufficient vacancies, and therefore proposals shall be forwarded to other departments as per clause 15 of the OM dated 1/6/2015, my lord, for recommendation. Now, my lord, as per my next paragraph, this page 44, my lord.
Yes.
As per my RTI application, this serial number 10, Shantanu Nath, Lordship has got it. Shantanu Nath has already been appointed in 2023 itself. I have got the RTI.
What is the stand of the respondent?
Now, Shantanu, this who is below than me, he has been appointed. And I have got the.
Who is to make the appointment?
This director of veterinary department and SLC, my lord.
Who is the veterinary?
Yes.
Veterinary department?
Lordship.
Where is the, has the SLC passed any order?
No, SLC only considered that aspect, my lord, and considered, but could not be recommended because of insufficiency of vacancy at that moment in 2022. And it has been said that in other departments it will be forwarded. Now my case was forwarded, my lordship, kindly see.
Cultural affair.
Cultural affair. And cultural affairs, lastly, they have, in my RT also, it has been said that now they do not have the vacancy, my lord. Now, only in my affidavit in reply, I have said that since 5,000 posts, grade 4 posts already been appointed. There are so many posts, my lord. But once it is directed to the SLC, my lord, they will consider, my lord, because since 2022, matter is pending without any consideration, and that too some junior to me have been appointed. So only if lordship will direct the SLC, my lord, to consider, they will consider, considering that since junior to me have been appointed.
No. Page number 48.
Yes.
Shows that there is some vacancy in the cultural department.
48, lordship.
Yes.
48, lordship, yes. As per this, their letter, my lord.
As per their letter.
Yes, as per their letter, my lord.
So you are at serial number 1.
Yes. To here, my lord, in terms of this, this letter, this honorable court passed an order on 3rd of October, my lord. This, with reference to the subject matter, I have the honor to state that out of the eligible 11 numbers of recommended grade 4 candidates as per SLC minus dated 13/9/22, 2 numbers have already been proposed for appointment as heavy constable in the Department of Home and Political Department. Now, against the vacancy in Cultural Affairs Department, the name of Sri Bipul Raba of son of stands at serial number 1 in the selected eligible list is proposed for appointment. Now they are saying that in the veterinary, this Cultural Affairs Department, there is no post. They have informed to the authority concerned of the Director of Veterinary. And if the Honorable Court, Lordship, kindly have a look the Honorable Court's order at order dated 3/10/24, my lord. This Honorable Court's order.
Some instructions were directed to be.
Exactly, my lord. Here, whatever they saying that there is no post, all these things, it's a fallacy. The Honorable Court observed.
Lordship. As per my instruction, Lordship, that was forwarded to veterinary department, Lordship. After that, regarding the culture department, I have to sort instruction, Lordship.
No, but who's for veterinary?
Pending council is there, Lordship.
You obtain your instruction.
Lordship.
Later get the instructions, what has happened to the cultural affairs post.
Lordship will specify, my lord, since junior to the persons, my lord, this petitioner already been appointed, my lord.
And have a bit of the meeting indicated please know but issued by the director and even the paid by the director. From our each principal secretary government staff, animal husbandry and veterinary department. It was informed that one vacancy in cultural affairs department is available to name the person standards scale for one of the selected individual for the proposed point. There are right of given orders passed by the court permitting the respondent to be verified. Let instructions be placed for the court as the status of the vacancy taken to be available to the cultural department and what steps are being taken by the responsible authority for consideration for appointment. Judgment ground. The petitioners demand that were standing below you.
Yes, below me.
Below the have already been appointed. Here. Let this instruction be placed here. Court on 21st July.
Public.
You're right, Lordship.
Please, the law. Today was fixed for the consent and disclosure from honorable arbitrator will.
Yes, sir. No?
Good morning.
Pursuant to the earlier order dated 13/6/2025, passed by this court. Srimati Chayarani Goswami, retired district and session judge, Assam, was appointed as the proposed arbitrator. Was proposed to be appointed as an arbitrator to decide the disputes arising by and between the parties in respect of contract work relating to last order and last order. The description of the work, artwork, and happy. The written declaration submitted by the prospective learned arbitrator, ID, communication dated 19/6/2025, is placed before the court by the counsel for the petitioner, and the same, a copy of the same is also available in the case report. That view of the matter, the appointment of Srimati Chayarani Goswami is hereby confirmed as the sole arbitrator side and arbitrate on the disputes arising by and between the parties in respect of the contract for the work so and so. The parties will appear before the arbitrator on within 4 weeks.
After 4 weeks.
After 4 weeks. Stop. The arbitrator will thereafter proceed to commence the arbitration. So, copy of this order be communicated to the learned arbitrator is going to by the registry of the court. Parties will also appear before the arbitrator along with a certified copy of this order.
I am paying for all the respondents.
Mr. K. Gogoi appeared for all the respondents. Arbitration petition disposed of.
Deeply.
Pleasure.
File, they have filed the affidavit in this case. Today in the morning, we also have filed a reply. So it will come up after vacation now.
Mr. D. Das, that a senior counsel assisted by able to submit that the rejoinder affidavit of the petitioner has been filed today. And stop. The same, however, is not available in the case record. It is Ardeka. The counsel appears for which part?
Water issue.
Water resort. It's the meeting the company matter be listed for admission.
Until August,
August.
anytime.
Eighth of August.
Interim order will come.
Interim order passed earlier.
I'll be obliged.
Mr. Goswami, there is one thing that we were unable to find out here. The grounds raised by them is that they're challenging the proceedings also. That the complainant was never produced as a witness. He was never examined.
Right. That is there.
We have not found your
Yes, yes, that is correct.
reply. Now, if the complainant is not examined,
My lord.
what is the nature of inquiry that you have conducted?
Uh,
The complaint,
no,
the inquiry is on the basis of charges
yes.
which emanate from a complaint.
My-
It's not something which is.
No, here is a case, my lord, where petitioner was caught red-handed, my lord. And its admitted position was according to the
Is there any
petitioner,
admission?
my lord.
Is there any admission by the petitioner that he has?
No, that is not disputed, my lord. It's a process, my lord. The authority by whom my lord, that was conducted. Which no,
Admission. There is no admission.
my lord.
There is no admission by the petitioner that he has accepted the money or something like that.
No, according to him, my lord, according to petitioner, my lord, money was thrust to him, my lord. According to the petitioner, my lord. That part is there, my lord.
He never accepted lordship and there was no eyewitness also.
And it is an admitted position that he took the money and he was caught red-handed. That part is there, my lord.
He never accepted that he never
And you were before the court challenging this proceeding without going to an appeal because according to you, de novo proceedings not maintained.
not maintainable lordship. You know, for inquiry on same set of charges is
Yes,
not
de novo
possible.
cannot be, my lord, cannot be initiated, my lord, based on fresh charges, my lord. De novo is already in respect of the charges, my lord. Petitioner cannot,
There are rule 9 there is
because fresh charge cannot be framed, my lord.
same set of charges.
Yes, same charges, my lord, based on the same cause of, my lord, so cause only list of witness on their demand, my lord. List of witness and the, my lord, statement of allegation and the documents, my lord.
Yes, so was only not examined, never presented
No,
for
he
cross
was-
examination lordship.
He was not shown as primary witness, my lord.
But he had the right to cross examine him.
And the de novo is entirely to give his ample opportunity, my lord, on his demand.
Not. Even the judgment they are denying about de novo inquiry up to that also says that against them.
All right, we will, we did not want to reserve it.
In
We-
fact, hearing is concluded, lordship.
Hearing is concluded, only on that part we wanted some clarification.
Yes,
We will keep it on reopening, because if we reserve it,
my lord.
it would be beyond July. We'd like to keep it on 17th of July.
70,
July,
17.
we only have to pass the order. You are not available,
My lord,
22nd,
20.
22nd July.
Yes, sir.
It's not.
I think nothing
If
remains,
we reserve it,
my lord.
there is a possibility it might get delayed. So we are keeping it on 22nd, deliver the order.
So far, our part is concerned, I think, my lord.
Yeah, hearing concluded. Hearing concluded, matter be listed for order.
Because that
22nd of July.
the issue, my lord, that issue has also been clarified by from our side. And the petitioner was never exonerated from the charge, my lord, the charges, my lord. Even in first,
You think a de novo inquiry is
All right,
all right.
we are what to do with the record?
Yes, record is
Can hand it over to the court.
yes. Only thing, lordship may record it, my lord. Record has been produced, my lord.
Record. Just remember to take it back.
Yeah.
After the
Yes. Obliged.
You're right.
Obliged.
Yes.
Yeah, lordship, we have received the inquiry report here, okay?
Was it served?
It was not served before passing the impugn order. Report. But subsequently it was served upon him on the basis of a RTI petition referred by him. But in the
What about the appeal? You filed an appeal.
No, we didn't file.
Why you did not file an appeal?
Because the order was passed by the commissioner, only that's why, no?
Who is the appellate authority?
appellant is now the secretary.
Secretary.
Yes, it was passed by the
Commissioner.
commissioner. Impugn order.
Page 14. Page 14.
Yes. Yeah, government is this in appellate report. On that. Oh, wait, telling people.
You did not participate in the inquiry.
No, he participated.
Participated.
He participated.
My case is this. Let me please, my lord. My lord, pursuant to focus notice, my lord, I replied my reply. Then thereafter, my lord, there was, it was stalled, nothing happened. My lord, I came before this honorable court, my lord, for praying for, my lord, concluding the DP within a specific time frame. That writ petition was disposed of, directing them to complete the proceeding within 2 months by complying with all the procedures that is required to be followed. Then thereafter, I was called to appear before the inquiry committee. That was on the 8th of March 2013, my lord. On 15th, I was asked to appear. I appeared. My lord, if lordship goes, because my instruction is this, my lord. The witnesses were never examined in my presence. I was not allowed to cross-examine the witnesses. Well, that is my case. But my case is, my lord, there has been a procedural lapse at every stage. Line 2, my lord,
Why
list of
don't you go and appeal? All these issues can be pressed out in the appeal.
but my lord, that those provisions, mandatory provisions, my lord, of list of witness, furnishing of list of witness, list of documents has not been done, my lord. But that has had to be mandated by this honorable court.
Therefore, but you filed an appeal, isn't it?
But that appeal was against suspension, my lord, not against.
Appeal suspend.
Yes. And then after, my lord, I was reinstated in service also. But my case is.
What was the order passed here?
Which one, my lord?
Remove.
The remove from service and some recovery of some amount. And lordship will kindly see in the so cause, my lord, the amount which was given is 10 lakhs 14,000. Ultimately, in the inquiry report, the amount fixed was 63 lakhs 52,000. Even one of the allegations was specific. The charge was not specific. And at every stage, my lord, the procedural lapse is there. And lordship knows, my lord, that 72 judgment, my lord, of our honorable court, the full bench decision, my lord, has held, my lord, that this rule 9 to be mandatory, my lord. It has to be followed.
No, 9 is mandatory.
That is why the appellate provision is there.
But my lord, appeal will come, my lord, once they have followed the procedure. The procedures were never followed. And lordship may kindly come to annexure B at page 20, my lord. I'll just show that they have not even mentioned the list of witnesses and the list of documents. Lordship may kindly come to page 20.
Did you file your reply?
Yes, I have filed.
Where is that reply?
Lordship will find that at, my lord, see, my lord, 23, page 23. I have denied all the charges.
So you have filed your reply. You did not ask for, did you ask for examination of document?
That is not required, my lord, because list of documents and list of documents and list of witnesses are mandatory to be given to me.
Mandatory, but you have filed a reply without looking into it.
Yes, but my
Either you file a reply or you don't file a reply.
Yes.
You filed a reply.
I filed my reply.
You filed a reply without raising an objection that these documents were never given to me.
Yes.
I was never given an opportunity to be confronted with this document. Where is
But
that
my lord,
statement?
fact remains, my lord. The word used is invariably, my lord. It has to be some furnished to me.
Whatever.
My asking or not asking, my lord, doesn't matter.
No, your asking matters because you have filed a reply.
Yes.
Unless you are prejudiced. Unless you are prejudiced.
Yes, but I have.
Reply doesn't appear to have prejudiced you.
No, my lord, that is there, but my lord, the fact remains.
Unless you
The
are
law,
prejudiced.
law is there. Law says, my lord,
No,
it has to be furnished to me.
Says, but
Yes.
law also says that unless you show your prejudice, mayor asking you will not get an interference with the proceedings like that.
But that is true.
Then?
But my lord, the wording of my lord 9.2 is, my lord, it has to be invariably, my lord, furnished to me.
No, therefore you show us the prejudice.
Prejudice is the cost to me. I have hesitated
the
with petition also. They have not denied.
Mr. Kumar, do you have the records?
Yes, sir.
Do the records reveal that any proceeding has been undertaken? Did he appear?
Your lordship, he appeared in the inquiry report. It appears, your lordship. Sir.
Do you have the copy of the inquiry proceeding book?
Yes.
Forget the report. Don't examine records now. Have you not gone through the report? Heard counsel for parties list again on 15th of 17th of July. Enabling the learned additional AG, Mr. K. Kumar, apprise the court in respect of the proceedings undertaken during the inquiry proceedings stated to have been inquiry proceedings against the petitioner, which is presently assailed in the present proceedings. Mr. Kumar will apprise the court whether the petitioner participated in the inquiry proceedings that whether the same is reflected in the records maintained by the department. Based on 17.